They handed me the termination papers at 4:47 p.m. on a Wednesday. At 2:13 a.m., my phone rang with an unknown number. The voice belonged to their senior counsel, and he was shaking. "Mr. Hamilton, please tell me you didn't actually sign those documents." I stacked the termination papers neatly on my nightstand. "I signed exactly what you presented to me, Dennis. You might want to check Section 12B, subsection D. Terminations based on regulatory compliance require documented clearance attached as appendix materials. I see no appendices. Your move, my name is Roger Hamilton. I'm 51 years old, and I just caught my former employer in the biggest FDA violation of their corporate lives. Before we continue, let me give you the background here. 19 years in pharmaceutical quality assurance, the last 14 at Omicron Pharmaceuticals, working my way up from compliance specialist to director of quality assurance. I'd overseen 47 major validation protocols during my tenure. Protocols that kept our FDA manufacturing license worth approximately $850 million in annual revenue. I'd restructured the deviation reporting system, cutting non-compliance incidents by 31%. I'd implemented automated batch record verification that reduced FDA 483 observations by 52%. I'd built the quality assurance department from 9 people to 43 people. For all those contributions, I'd been terminated at 4:47 p.m. on a Wednesday afternoon for consistent performance deficiencies that nobody would actually spell out for me. You know what's funny? I'd seen this coming for months. Gary Morrison, our new COO, had been making noise about operational efficiency and streamlining legacy processes ever since he'd joined the company 11 months ago. Translation, he thought experienced guys like me were expensive dead weight standing in the way of his cost-cutting agenda. Let me tell you about Gary. 38 years old, MBA from some prestigious school, consulting background. The kind of guy who walks into a pharmaceutical company and thinks FDA regulations are just bureaucratic red tape slowing down profits. He'd been dropping hints in meetings about how other companies managed quality assurance with leaner teams and more flexible approaches to compliance documentation. Every time he said stuff like that, I'd feel this knot in my stomach. See, my father died from a defective heart valve back in 1987. Manufacturer had cut corners on quality testing to meet quarterly targets. Dad was 58, same age I am now, when that valve failed during what should have been routine surgery. I became a quality assurance professional specifically to prevent other families from going through what we went through. So when Gary Morrison started talking about flexibility and compliance, I knew we were heading for trouble. The termination package sat on my kitchen table at 11 to 23 p.m. that Wednesday night. 3 identical copies, all signed with my full legal name, every signature line filled in, every initial placed where those yellow tabs told me to put them. I'd spent 47 minutes reading through all 28 pages of legal documentation that Omicron Pharmaceuticals had prepared for my departure. The severance terms were standard corporate stuff. 119 weeks of pay, 1 week for each year I'd given them, health insurance through March, the usual non-solicitation and non-disclosure language. What caught my attention wasn't what they'd included. It was what they'd forgotten to attach. Section 12B, subsection D, buried on page 9 between clauses about intellectual property and equipment return. In cases where termination results from regulatory compliance deficiencies, this agreement shall incorporate by reference all FDA clearance documentation, deviation reports, and compliance evaluative materials relevant to said deficiencies attached herein as Appendix C and forming the regulatory basis for separation. I'd written that exact language myself 7 years ago when I'd been promoted to director and asked to overhaul Omicron's employment policies. I'd seen too many quality professionals get dismissed right before FDA inspections. Too many careers destroyed with no documentation trail, no accountability, no regulatory justification. So I'd built protections into the system. Protections that required documentation, evidence, due process. Protections that required companies to actually prove regulatory cause before destroying someone's career who knew where all the compliance bodies were buried. The thing is, I'd seen this game played before at my previous job. New executive comes in, wants to clean house, targets experienced employees they view as obstacles or expensive liabilities. But instead of admitting they want lower paid staff or fewer regulatory watchdogs, they manufacture performance issues, create some story about poor attitude or failure to adapt to new efficiency standards. Most people don't fight back when this happens. They take the severance, sign the non-disclosure agreement, and move on quietly. They're overwhelmed by the shock of termination, worried about money and health insurance and finding new work. They don't have the energy or resources for a legal battle against a pharmaceutical corporation with deep pockets and high-priced lawyers. But I wasn't most people, and I'd specifically written policies to prevent exactly what just happened to me. Protections that Omicron's HR department had apparently forgotten existed when they decided to fire me for consistent performance deficiencies and failure to meet compliance benchmarks. My phone lit up the darkness, unknown caller, area code 6117, Boston, where Omicron maintained their legal operations center. I let it ring 6 times before answering. Sometimes it's good to let people sweat a little. Roger Hamilton speaking. Mr. Hamilton, this is Dennis Wheeler from Omicron Pharmaceutical's legal counsel. His voice had a tremor I'd never heard in our previous interactions. I apologize for the late hour, but I need to ask you something urgent about the separation documents provided this afternoon. I'm listening, Dennis. Have you executed the non-disclosure provisions of the termination agreement? I glanced at the papers on my table, my signature on page 21 directly above the NDA section. I lined up the document edges nice and straight. I signed everything Omicron provided me exactly as your HR director told me to. Mr. Hamilton, I need you to understand something critical. There may have been a documentation error in the materials we supplied. We're prepared to offer you a chance to review revised paperwork. What sort of error? I kept my voice steady. Years of dealing with FDA inspectors had taught me never to show my hand too early in negotiations. I'm not at liberty to discuss specifics over the phone, but if you haven't yet executed the agreement, we'd appreciate scheduling a meeting to address certain corrections. I executed all documents at approximately 7:30 p.m. this evening. Scanned the completed package and sent it to your HR department at 7:51 p.m. Is something wrong with your documentation? The pause stretched so long I wondered if the call had dropped. I could hear background voices filtering through. Someone was running an emergency meeting at Omicron's legal offices at 2 in the morning. That told me everything I needed to know about how serious this problem was for them. Mr. Hamilton, Dennis's voice came back tighter now. Can you clarify what you mean by executed all documents? I mean, I signed the separation agreement as presented, every page and initialed where indicated, every signature line completed. The full 28-page document that HR Director Carol Henderson handed me during my termination meeting at 4:15 p.m. today. And the appendices, did you review the attached appendices? What appendices? The document I received contained no appendices, just the 28-page separation agreement. Another long silence. I heard someone curse in the background. Multiple voices now. This wasn't just Dennis working late. This was a full crisis management team assembled at 2 a.m. on a Thursday morning. Then Dennis's voice, barely keeping it together professionally. Mr. Hamilton, the separation agreement should have included appendix materials. Specifically, if termination was classified as compliance-based, there should have been regulatory clearance documentation attached as Appendix C. Should have been. Dennis. Interesting choice of words, because according to Section 12B, subsection D of the separation agreement I signed, compliance-based terminations must be accompanied by FDA clearance documentation. Not should be, must be. I pulled the document closer and read the exact language while stacking the pages into a neat pile. Quote, this agreement shall incorporate by reference all FDA clearance documentation, deviation reports, and compliance evaluative materials relevant to said deficiencies attached herein as Appendix C and forming the regulatory basis for separation. End quote. Dead silence. I could practically hear him sweating through the phone. I count 0 appendices attached to the document I received and signed. I continued, my voice getting more direct, which means either my termination wasn't actually compliance-based, in which case you guys need to explain why your termination letter explicitly states consistent performance deficiencies in regulatory oversight, or my termination was compliance-based, but you failed to provide the mandatory documentation, rendering the separation agreement invalid because it violates your own policy requirements.
Mr.
Hamilton, either way, Dennis, I think we'll be seeing each other in court. You might want to get some sleep. Tomorrow's going to be a long day for Omicron's legal team. I hung up before he could respond. Sometimes you have to let people know exactly where they stand in the compliance chain. My wife Linda had been listening from the hallway in her bathrobe. You planned this whole thing. I planned for the possibility they might fire me without following proper procedures, I said, tapping the documents into perfect alignment. I wrote those procedures specifically to prevent what happened today. Vague performance accusations with no documentation, no improvement plans, no objective metrics tied to actual FDA requirements. What happens now? Now we wait to see if they try to create documentation after the fact, which would be fraud, or claim the appendix materials aren't actually required, which contradicts their written policy, or try to settle this quietly before it becomes public knowledge that they're systematically firing quality professionals without proper regulatory documentation. Linda poured herself a glass of water. Which outcome do you want? Honestly, I want them to take me to court. Discovery in a wrongful termination lawsuit would expose how many other people they've dismissed using identical vague performance accusations without proper regulatory clearance. I'm betting that number is a lot higher than Omicron wants their FDA contacts to know about. Let me back up and tell you how we got to this point. The termination meeting had been brief and uncomfortable. Carol Henderson from HR and Gary Morrison sitting across from me at that polished conference table like they were about to deliver bad news about a family pet. Roger, we need to discuss a serious matter regarding your performance. Gary had started, staring at his notepad instead of making eye contact, already a red flag. What performance issues? I'd asked directly, no point dancing around it. Multiple stakeholders have raised concerns about your regulatory oversight and management effectiveness. After thorough consideration, we've determined your performance doesn't meet Omicron's current standards. We're terminating your employment effective immediately. Classic corporate double talk. Lots of impressive words that said absolutely nothing specific. What specific performance deficiencies are you talking about? Which FDA requirements am I supposedly failing to meet? The specifics are documented in your personnel file. What matters now is transition planning. I'd like to review that documentation of alleged compliance deficiencies. That's not necessary for this discussion. Carol had jumped in quickly. We're prepared to offer you a comprehensive separation package if you sign the agreement today. They'd slid the document across the table like they were doing me some kind of favor. I'd taken 32 minutes to read it thoroughly while they sat there in uncomfortable silence. Most people would have felt pressured to sign quickly and get out of there. But most people don't understand that taking your time to read regulatory documents isn't just smart. It's absolutely essential for maintaining compliance integrity. The terms were standard enough: 19-week severance, benefits continuation, non-compete clauses that wouldn't hold up anyway. But what jumped out at me was the termination classification. Termination for cause, performance deficiency in regulatory compliance oversight, and the complete absence of any attached performance improvement plans or FDA clearance documentation. Here's the thing, I'd signed it anyway, initialed every page, filled in every signature line, because I knew something Gary and Carol apparently didn't know. Their own policy required FDA clearance documentation for compliance-based terminations. By signing an agreement that lacked those materials, I was actually documenting their policy violation. Some people might call that setting a trap. I call it holding people accountable for following their own rules. Thursday morning at 8:27 a.m., I got an email from Dennis Wheeler that confirmed everything I suspected. Mr. Hamilton, following our conversation last night, Omicron Pharmaceuticals would like to offer you the opportunity to meet and discuss revised separation documentation that addresses certain procedural oversights in the original materials. We believe revised documentation would serve both parties' interests. Can you be available Monday morning at 10 a.m. at our offices? Procedural oversights. That's pharmaceutical lawyers speak for we screwed up big time and now we're scrambling to fix it before the FDA finds out. I forwarded the email to my attorney, Craig Anderson, who specialized in executive employment litigation and had represented plenty of pharmaceutical executives in wrongful termination disputes. Craig had handled my contract negotiations when I'd been promoted to director, so he knew my background and what we were dealing with here. They're panicking, Craig said when I called him 20 minutes later. They realized they terminated you without following their own regulatory procedures, and now they want to fix it after the fact. Can they do that legally? Not really. You already signed their agreement. They accepted your signature by processing your termination. They can't now claim the agreement was invalid just because they made documentation errors. Either the agreement is valid as signed, meaning they violated their own policy, or the agreement is invalid, meaning your termination is also invalid. So what's our next move? We go to this meeting Monday and see exactly how deep a hole they've dug for themselves. Monday morning, Craig and I showed up at Omicron's headquarters at 9:55 a.m. Security escorted us to a large conference room where Dennis Wheeler waited with two people I didn't recognize. A guy in his 50s who introduced himself as Todd Brennan from Omicron's outside counsel firm, and a woman in her mid-40s who turned out to be Diane Foster, Omicron's chief financial officer. The fact that they'd brought in outside counsel and the CFO told me this was way bigger than just a documentation error. This was full-scale damage control at the highest corporate level. Mr. Hamilton, thank you for coming. Dennis started. I think we can resolve this situation in a way that works for everyone. I'm listening. I kept it short. Let them do the talking and show me how much trouble they knew they were in. Todd Brennan opened his tablet and pulled up a document. We've prepared revised separation documentation that addresses the procedural issues with the original materials. The revised agreement includes the regulatory clearance documentation that should have been attached originally, properly documenting the compliance deficiencies that led to your termination. You created FDA clearance documentation after you fired me, I said. Not a question, a statement. We compiled written documentation of regulatory concerns that had previously been communicated verbally. We're now providing them in written form as required by company policy. Craig leaned forward. Mr. Brennan, regulatory clearance documentation should be created and filed before termination, not fabricated afterward. Creating them retroactively to justify a termination decision that's already been executed isn't consistent with proper FDA compliance procedures. The documentation reflects genuine concerns that were communicated to Mr. Hamilton prior to his termination, Todd said carefully. Then why wasn't it documented at the time? Craig asked. Why wasn't it attached to the original separation agreement as required by Omicron's own written policy? There was an administrative oversight. We're correcting it now. Diane Foster spoke for the first time. Mr. Hamilton, perhaps we can approach this differently. Omicron is prepared to offer significantly enhanced severance terms. 31 weeks of severance instead of 19, extended benefits continuation for 24 months, and a mutual agreement not to pursue litigation in exchange for signing the revised separation agreement with the attached regulatory documentation. Craig and I exchanged glances. This was significant. They were essentially offering to pay me an additional 12 weeks of severance, approximately $127,000, to accept documentation that should have been provided initially. What's in this performance documentation? I asked. What specific deficiencies am I allegedly being accused of? Todd turned his tablet toward me. 4 written statements, each from different Omicron managers, claiming various performance issues. I read each document carefully, taking my time while they waited uncomfortably. The statements were vague, non-specific, and critically. None included specific dates, specific incidents, specific metrics, or specific examples of the alleged deficiencies. These documents are completely generic, I said, sliding the tablet back toward him. Alan Powell claims I failed to meet efficiency targets, but doesn't cite a single specific target or metric. Beth Turner claims I showed poor judgment in regulatory decisions, but doesn't identify which meeting, which decision, or which regulation. The third statement claims I resisted new compliance methodologies, but doesn't specify which methodologies or when this resistance supposedly occurred. But then I noticed something else that made their desperation even more obvious. Ray Valdez hasn't worked at Omicron for 8 months. He resigned to take a position at a competitor before Gary Morrison even joined the company. How exactly is he providing performance documentation about my current work? Todd's expression froze. This was the moment I knew we had them completely. Mr. Valdez provided the documentation based on his observations during his employment with Omicron. But Ray Valdez left Omicron before Gary Morrison even started here. He couldn't possibly have observations about my performance under Gary's leadership, which is supposedly when these performance issues became serious enough to justify termination. You're using testimony from someone who wasn't even present during the relevant time period to justify firing me. Craig was typing rapidly on his laptop. Mr. Brennan, using a former employee who left the company months before the alleged performance issues occurred as a witness significantly undermines the credibility of this documentation. A jury would have substantial questions about why Omicron couldn't find current employees willing to provide documentation critical enough to justify termination. Mr. Valdez's employment status doesn't invalidate his professional observations, Todd said, but his voice carried a lot less conviction now. Actually, it does, Craig said, because it suggests Omicron couldn't find current managers willing to provide sufficiently critical documentation about Mr. Hamilton's work, so they reached out to a former employee who has no current knowledge of Mr. Hamilton's performance. That's not proper documentation. That's desperation. We're not going to debate the validity of the performance documentation, Dennis said, trying to regain control of the meeting. The enhanced offer is on the table. 31 weeks severance, extended benefits, mutual release. Mr. Hamilton needs to decide if he wants to accept it or pursue expensive and time-consuming litigation for everyone involved. I looked at each of them in turn. Dennis, nervous and sweating despite the air conditioning. Todd trying to maintain professional composure, but clearly uncomfortable with the weakness of his documentation. Diane calculating financial exposure in her head. "We'll need time to consider," Craig said, standing up. "Mr. Hamilton will respond to your offer within 72 hours. We left Omicron's offices at 11:35 a.m. In Craig's car, he turned to me with a slight smile. "They're terrified," Craig said. "Did you see how quickly they tried to move past the Ray Valdez issue? They know that using a former employee who wasn't even present during the relevant time period is going to look terrible in court. So what do we do now? We investigate. We find out how many other people Omicron has terminated for vague performance deficiencies without proper documentation. We build a pattern and practice case showing this isn't just about you, it's about systematic policy violations. Over the next 4 weeks, Craig's firm conducted extensive discovery through professional networks, former employee contacts, and public records requests. What they found was even more damning than we'd expected. In the past 3 years, Omicron had terminated 23 employees for performance deficiencies. Of those 23 terminations, 16 had been classified as requiring performance improvement documentation under company policy. Of those 16, only 4 had actually included attached documentation at the time of termination. The other 12 had been fired without the required paperwork. Most of those 12 people had signed separation agreements and left quietly, but 5 had hired attorneys and filed EEOC complaints alleging discrimination. 3 had settled confidentially. 2 cases were still pending. More importantly, Craig discovered a pattern that made the whole situation even worse for Omicron. Nearly every performance deficiency termination had occurred within 8 months of a new executive joining the leadership team. The new executives would identify experienced employees as obstacles to change or budget reduction targets, then work with HR to manufacture performance allegations that would justify termination without having to admit it was really about cost cutting. Gary Morrison, the COO who terminated me, had done this exact same thing at his previous employer. Craig found court records showing he'd been named in 3 wrongful termination lawsuits at his prior company, all alleging he'd fired experienced employees based on fabricated performance accusations. 2 cases had settled confidentially. 1 had gone to trial and resulted in a verdict against the employer. But the smoking gun came when Craig's firm subpoenaed Omicron's internal emails as part of the discovery process. What we found in those emails revealed just how deliberate this whole thing had been. 2 weeks before my termination, Gary Morrison had sent an email to Carol Henderson and Diane Foster with the subject line Q4 Cost Reduction Initiatives. The email read, "We need to reduce operational overhead by $1 million before year end to hit board targets. Recommend targeting senior quality staff with highest compensation packages. Roger Hamilton, $165,000 base plus bonus is top priority. He's been resistant to the new efficiency protocols anyway. Let's move on this quickly. What's the cleanest termination path?" Carol had responded, "Performance-based termination requires documentation per policy section 12B. We don't have current performance improvement plans for Roger. Creating proper documentation would take 60 to 90 days minimum." Gary's response, "Don't have that kind of time. Can we use past performance reviews or general feedback from managers?" Diane had chimed in, "Legal will want something in writing to justify performance termination. Can we get managers to document recent concerns?" Carol, "I can reach out to Alan, Beth, and Ray for written statements about performance issues." Gary, "Perfect. Get those statements and let's move forward. Keep this tight. Don't want him getting advance warning." That email chain proved several critical things. First, my termination wasn't about performance at all. It was about cost reduction. Gary needed to cut $119 million from the operational budget to meet board targets, and firing senior staff was the fastest path. Second, they knew they were supposed to have documentation. Carol explicitly mentioned the policy requirement, but instead of following proper procedures, they decided to fabricate documentation after the fact. Third, they deliberately tried to keep this quiet and move quickly to prevent me from defending myself. When Craig showed me those emails, I felt vindicated and disgusted at the same time. Vindicated because it proved everything I'd suspected. Disgusted because it showed how little Omicron valued the careers they were destroying for quarterly numbers. "This changes everything," Craig said. This isn't just policy violations anymore. This is deliberate fraud. They knowingly terminated you without proper documentation, then tried to fabricate documentation afterward to cover their tracks. We amended our complaint to include the email evidence and added a claim for punitive damages. We increased our damages demand to $2.8 million. That's when Omicron's settlement offers got serious. Within 2 weeks of filing the amended complaint, Todd Brennan called Craig with a new offer, $2.1 million. They're in full panic mode, Craig told me. Those emails are devastating. No jury is going to side with Omicron when they see executives openly discussing how to circumvent their own policies to fire someone for budget reasons. We countered at $2.6 million with no confidentiality clause. They came back at $2.2 million. We settled at $2.3 million. The final settlement included several key elements. $2.3 million payment to me. Written admission by Omicron that my termination did not follow proper company procedures and should not have been classified as performance-based. No confidentiality clause whatsoever. Agreement by Omicron to revise their cost reduction policies to explicitly prohibit using terminations as a primary cost-cutting mechanism. Agreement by Omicron to implement mandatory training for all executives on employment law compliance and proper termination procedures. And a personal letter of recommendation from the board of directors acknowledging my contributions to Omicron. The written admission was huge. Most settlements include no admission of wrongdoing, but the email evidence was so damning that Omicron agreed to admit they'd violated their own procedures. 6 months after the settlement, I got a phone call from Hugh Peterson, who'd been on Omicron's board during my termination. Roger, I wanted you to know something. The third-party audit we commissioned found significant policy violations in how Omicron was handling terminations. 14 employees who'd been fired for performance deficiencies without proper documentation. The board has approved a remediation fund to compensate those employees. Approximately $3.2 million across all affected people. Why are you telling me this? Because your lawsuit did more than get you compensation. It forced us to fix a broken system. Gary Morrison has been asked to resign. The entire HR department has been restructured. Employees at Omicron are better protected now because you refused to accept a separation agreement that violated policy requirements. Today, I run my own consulting firm helping other pharmaceutical companies structure employment policies that protect both companies and employees. My experience at Omicron has become a case study I use in presentations about why documentation requirements matter and what happens when they're ignored. The lesson isn't just about reading your employment agreement carefully, though that's important. The lesson is about understanding that employment policies exist for a reason. When I wrote that performance improvement documentation requirement 7 years before my termination, I was protecting future employees from exactly what happened to me. Sometimes the best revenge is simply making people follow the rules they agreed to in the first place. And sometimes when you stand up for what's right, you end up protecting a lot more people than just yourself. The most dangerous employee to terminate isn't the one who screams or threatens lawsuits. It's the one who quietly reads every word of what you put in front of him and knows exactly what those policies mean, especially when he wrote them himself. When corporations get careless with their own rules, they're not just breaking policies. They're handing you the exact weapon you need to hold them accountable. And sometimes that accountability protects far more people than just yourself.